Caroline, for all the effort and all the help. We really appreciate it.
Okay, cool. For the uninitiated, I thought I was very clever to come up with the idea of the Life of Pi. It is a book which I particularly enjoyed. It's a story of an Indian boy who survives a shipwreck, traveling with his family from India with their entire zoo on the ship. And he's the sole survivor, gets onto the life raft, and then invites Richard to join him. The only problem is Richard is a tiger. And he ends up with this very long journey in a very small boat with a very big tiger. And the artwork is particularly beautiful. So I have, in fact, been using Canva's free text-to-image AI to generate these spectacular images. And I have to say, over the months that I've been doing this, our tigers are getting much better. I'm contributing to the AI. Right, so on to what we're doing today. So first of all, just a bit about me. I have a little bit of kudos around working in IT for a very long time. I've worked in IT governance, I've worked in information governance, and specifically privacy and security governance over the last more years than I want to remember. And please just note that I am not a lawyer. I am in no way, shape, or form providing you with legal advice today. Everything I say is information only, and for you to go back and read it up yourself and to get legal advice and to decide what does or doesn't work for you, okay, or what does or doesn't apply to you. Thanks very much to Howard and the team for inviting me to collaborate with them on this exercise. The goal was to put the data back into data protection. I feel like the world went mad and just started running around with data protection and privacy, and without stopping to ask themselves what we already know about data management. So, for example, Poppy talks about you must manage the quality of the data, and guess what? Dharma Diambak explains how to measure privacy, not Poppy or privacy, quality. Fun. So we are here every second of the month, every second Wednesday of the month, and yeah, great to have you guys on board. Thanks for joining today.
And I really like that idea that you came up with, I think it was 2 months ago, Caroline, where we really battled to measure accuracy, and especially for our customers. And one of the things that we can do now is to have constant outreaches to them to update their information from a data privacy point of view. Now, I think that's fantastic for us as data managers, where accuracy is a real difficult thing to do. Now, we just doing good data management if we keep them up to date and keep the information up to date, which is what we need. So instead of finding nefarious ways of keeping them up to date, we can actually reach out to them and ask them to keep it up to date for us.
Yeah, there have been a lot of good spin-off benefits to privacy compliance. You know, I don't know if everyone on the call knows, but the OECD started the concept of privacy and data protection back in 1980. And they came up with the principles for lawful processing, which have been adopted by countries all over the world. So all of the privacy legislations are about 80% the same. So we can look at them to see what the different other legislations, what effects they're having or what impacts they're having. And we can learn from other legislations like we're going to do today. I'm going to show you how to leverage GDPR in the UK ICO to help you on your journey. But one of the nice things was there was lots of surveys done with GDPR when it first came out, and there were spin-off benefits to GDPR that were not expected. Things like increased customer trust, increased sales, increased even sense of security with employees, you know, sense of trust. So there's a lot of marketing benefits attached to privacy legislation. So it's nice to hear another example where the legislation is actually giving you a way of, and I think quite a nice, sensible way. I love privacy legislation. I think it's lovely and sensible and actually does kind of balance things out quite nicely. And we're going to talk a bit about balancing today because we're going to talk about sales, which is always a little unbalanced. Okay, so we've gone through the life cycle, and where we are now is in the enhance section. We started with disposal, by the way, because I felt like start at the end, know where you're going. And by the time we get to plan, you'll have all your bits and bobs together. So when we get to the end of the year, you'll know how to plan for all of this stuff because you'll have the detail. So we've worked through this and we're now going into enhance. And next month, October, we'll be talking about creating personal information. And the reference to the elephant, by the way, like this today's enhancing personal information is a tiger with a tusk and a trunk. I asked Canvas AI to give me a tiger / elephant enhanced tiger, and that's what they got. And in creating personal information, I was asking for a tiger-sized elephant. That's what I got. So you're making it up as we go along. All right. Okay. So I just want to give everyone a quick reminder. I am going to talk a lot about PAPIA, which is the South African Protection of Personal Information Act. We will talk a little bit about GDPR as well, but just for context, I'm primarily PAPIA focused, just because we're South African focused. But like I said, the legislations are 80% the same. If you want translations, please let me know. I will help you out. So just to remind you about the role players, there's always some sort of authority, and then South Africa's information regulator. We will talk today about supervisory authorities in the EU. Same kind of idea. So every country has some sort of regulator, authority, a commissioner who looks after data protection and data privacy. You always have your data subject. Everything starts with the data subject. So here we have our data subjects, and every company will have at least staff, if not customers, hopefully, and they have their personal information flowing into your organization. And when you are collecting data for your purposes and you decide how you want to process it or why it needs to be collected, you are the responsible party. In GDPR, that's called a controller. And then that data will flow out into your service providers, your contractors, your cloud systems, your software, your outsourced business processes, and those are then in POPI called operators, because they process personal information under your direction. So you have a contract with them and they satisfy your purposes. This is not for their purposes, right? So this would be like, we're going to talk today a little bit about HubSpot or Salesforce or Zoho CRM. They are operators, and under GDPR, the terminology is processor, right? So we have a controller processor relationship. In POPI, we have responsible party operator. Same thing though. I probably share the definitions line up beautifully. Any questions on that?
Yeah, I'd like to maybe just to add some interesting information. Today, I spent time building a data access agreement template and spent some time investigating, well, what's the difference between data access templates and data sharing templates? And the data access template is very much the type of thing that you'd want between yourself and your processor in terms of they're using the data, they have access. Yes, they have to deal with all of the purpose and those other definitions, but the access is more focused on the protection and the technical side of accessing the information than a sharing agreement between two different organizations. So it was quite interesting how different those agreements are set up.
Did that come out of your work in Saudi?
Yes, it's part of my work in Saudi. They've just come out with a PDPL.
Is that something that they've stipulated, data sharing agreement versus data access agreement?
No, it's we're building some templates for data integration, and one of the templates that we've just defined or looked at now is the data access agreement as part of data integration and data and elements like that, and differentiating that with a sharing agreement. So that was an interesting discussion.
Yeah, it's good to be specific like that. The equivalent, by the way, that's stipulated in GDPR is the DPA, the data processing agreement.
Okay.
Yeah. Which is very generic. It's something that should be slapped onto the end of every single supplier contract.
Right.
So, but yeah, it is interesting once you start going into like why we're sharing this information, what's the purpose, where we're going. So that would be, I'm going to touch on that a little bit today as well, actually. Just something I want to talk about is penalties. Penalties in these legislations are there because those particular privacy rights or risks have been deemed to be particularly risky. right? So you'll notice today that we're going to talk about one of the penalties in Poppy, which doesn't actually have a lot compared to GDPR. The penalty is actually there to give you sort of a heads up, a red flag to say, listen, if you're going to touch on this, if you're going to do anything that looks like this, you're treading on dangerous ground. You need to pay extra attention. And today we're going to talk about the privacy impact assessments, which are the way that you give extra attention to your processing. The other thing with penalties is these are the things that should be highlighted to your staff in your internal policies, right? So like your corporate, your group policies around, data protection or data handling. Whenever there's penalties attached in the legislation, that should be translated into some sort of a, hey, by the way, if you're doing something like this, like today we'll talk about automated processing. If you're doing automated processing, you don't have to become a lawyer. Just come to your compliance officer and double check that you're still within the bounds of compliance. Okay. So we don't want our staff to become lawyers. We want them to follow policy. So in Poppy, it's pretty straightforward. We have, in my mind, 3 key risks that you have to manage. There's one other, which is ignore the regulator. Our first fine has just been issued in this country because they ignored the regulator. So yeah, we don't want to do that. But in Poppy, the other thing is, surprisingly, your highest penalty is attached to the way you manage account numbers, and that means financial account numbers. So we've touched on that a few times. Today, we're going to look deep dive prior authorization and exactly what that's all about. And then everything else is pretty much around civil remedy, which is when people complain. And interestingly, there is an investigation ongoing at the moment by our information regulator on a very large, mainly internet-driven business, where they were not, people couldn't unsubscribe from the direct marketing, and enough people complained to the regulator, not on Hello Peter, by the way, to the regulator, so that the regulator said, we better pay attention, and actually went and did their own investigation, and that obviously becomes the whole thing. So don't ignore the regulator, don't ignore data subjects. Right, enhancing personal information. Let's go. So today we're going to talk about how to not make monsters. All right, and specifically merging data sets. This is one of the things where we are able now to be particularly clever. It might be on big data scale, or it might be you with your Power BI. It's more than possible nowadays to combine data sets. Right, so 3 topics we're going to look at. I want to give you a very specific example of how one case study around the use of purchasing sales leads. So something a lot of people do. It's one of the instances where we merge data sets, and it is kind of risky. A lot of data protection professionals will tell you just don't do it. Point is, we are going to do it. So I want to give you an example today of how to do it. Now, the diagram I'm going to show you is one that I did 2 months ago, where I actually showed you how to build one of these diagrams, how to do a data flow. So I'll do it again today, and it'll help you to see how we can use diagrams to communicate risk. Then we're going to talk about risky business, which is how to assess risk that is posed to the data subject. And I'm going to show you a Excel template that I use. It happens to be based on the OneTrust risk framework, but you can tweak it. But it's a risk methodology, and it's augmented to assess the risk to the data subject. And I'll show you where I got that from and why I did it that way. Then we have the compliance check. So there's 2 things. When you're merging data sets, particularly in Poppy, you have to have prior authorization. There's very specific instances where you've got to go for prior authorization. So I'm going to explain what that means. And then in GDPR, it's prior consultation. So I wanted to unpack it a bit because we haven't really done that in any of my talks yet. All right, so there's quite a bit to get through, so we're going to move quite fast. But I think you'll get the idea as we go. All right, so let's talk about buying data sets, buying sales leads. the reasons we do it, the pros are pretty obvious. This was an article I found. I did a very quick search on Google, and guess what I found? You know, an article about combining data sets without compromising on trust. And this is the whole point about like any privacy legislation is me. If I'm your data set, if I'm a data subject, if you approach me with data that you know about me, I shouldn't be surprised, right? I shouldn't feel like, wait, how did you get that data? I had it once where I applied for a credit card with a new bank, brand new bank. In fact, they were a new bank. They hadn't even existed for a while. And I gave them my national identity number, which in South Africa follows you from the age of 16 through your life. And they said to me, oh, and then they gave me you're Caroline, and they gave me my maiden name. I'd been married for 20 years at that point. And they gave me an address that I had forgotten I'd ever lived at. And they told me, they gave me a phone number, and they gave me, like, it's like, what on earth? Like, how did you even have that data? And they couldn't tell me. All right. So we mustn't surprise data subjects. It's one of the rules of thumb around privacy. So, but combining data, so let's just say we get sales leads. We purchase these things. Why would we do it, right? The pros list. These are just the pros listed from this article, and I think they're pretty much on point. And the cons to the data subject are that obviously the more data we combine, the more intrusive it becomes, the more sensitive and granular the data becomes. The way we combine the data, how clever we get, whether we're going to augment it with, whether we're going to use AI to help us to do it, to scrape data off the internet. We have to start being kind of careful about how intrusive we become. And we have to be, it really helps to think about it from the point of view of the data subjects. I'm going to give you very clear guides on how to do that today. Okay. So what's the pros of being privacy compliant, right? Complying with your data protection laws. Well, most of the data we buy is global. It's out there. I'll show you one today, which is Lucia. They're based in America, and we have all of these different privacy legislations. But the bottom line is that you don't know what that company's privacy requirements are. So if you look after your own privacy compliance, accessing data on the global market becomes a little bit safer. Complying with privacy, as we were just discussing, is a bit of benefits, a lot of customer experience benefits, a lot of trust. I actually have an entire talk up where I just talk about customer experience and privacy. And the reduced risk, obviously, for penalties, right? The problems, though, is that we now want to be all innovative. We want to, find new markets and new products, and we feel quite impatient about all that stuff. But the problem is that any compliance policy slows things down and says, hold on, just stop for a second. Let's first see, are we compliant? Privacy impact assessments, PIAs, or personal information impact assessments, or data protection impact assessments, are kind of expensive to do when you deep dive them. It can take a bit of time. You've got to get a lot of people in the room. You've got to draw pictures. You might need a consultant. You don't want to do this for everything, but sometimes you have to. And if you have to apply for prior authorization or prior consultation, it can take some time, up to 2 months, before you get the go ahead to allow you to do the processing at all. Okay. I don't know, Howard, if you want to just interject very briefly with the example of us purchasing sales leads that you've seen in the past.
Sure. I was involved or called on by a company to build a BI system, and part of the things we started finding was some serious quality issues with the customer data. And it was almost to a point where they said, well, is this customer data worth it? And one of the persons piped up to say, they know of the ability to buy some of this data from a big telco and then supplement the data or enrich the data with the information coming from the telco. And in some cases, adding new customers, depending on some of the address information to a sales pipeline or a sales funnel. So what we did was we got these loads of Excel files with all sorts of customer data and their phone numbers and addresses. And we then went through the process of trying to do this match and load and add cell phone information that, and because it was so long ago, the cell phone information was bad on the insurer's behalf. But of course, Telco had all of that data, so they really enjoyed that. And we spent lots of time trying to build a comprehensive view. Of course, part of our problems were that our matching algorithm wasn't great. So J Smith dot Joan Smith or Jane Smith, those are the type of challenges we faced. And it was quite, I feel quite bad about it now, but it's a case of, oh, well, this is the closest we can get using some form of fuzzy logic, remove some of the vowels and just try to do a match and load the data in. And then said, well, go for it now that you've got some data. It's a bit embarrassing at this point in time, but that's the way we did it.
Well, I mean, it showcases another reason why we would want to do it, you know. I mean, yeah, when there's gaps in our own data that we need it, it's very handy to go and just get it. Yeah, I think I must open up the Lucia website for you to show you what they're doing. They've got AI scraping.
Yeah.
All sorts of clever things. Yeah. So I suppose, like, people come to me and the first question they ask me, like, so with either of these examples, right? Like we want to increase our sales and marketing. We want to find contact information for more people who might be interested in profile of people, or we get missing some data in our database and we want to augment that. The first question, of course, is it okay? Can we collect data from sources other than the data subject? In POPI and GDPR, the preference is definitely collect directly from the data subject. That's always the preference, and should be your first point. You know, like, if you can collect it directly from the data subject, do that. But in a nutshell, yeah, you can. The law does allow for you to collect data from other sources. In POPI specifically, Section 12, if the data subject has made the data public record, so if they themselves have made a public record. So for example, if my LinkedIn profile's privacy settings are set to, like, expose me to, like, just, you know, share everything with the whole world, there are lots of scraping softwares that are going to come and pick up that data and add that to these data sets that get sold. So yeah, looking at the internet, reading up about people, looking at what's on public record, absolutely, as long as it was shared by the data subject themselves. You obviously always consent from the data subject, right? We've spoken a lot about consent in other talks. I'm not going to talk about it here, but if you have questions about consent, please let me know, because it's one of the least understood requirements in privacy. But consent from the data subject, or if it's a child or a minor, then consent from the parent or parenting unit, whatever that might be. Then, of course, you might say, well, it's a legitimate interest of the data subject that we do this, and when, you know, we're not impacting on their data rights in any particular way, so we feel like it's fine. There are tests you have to do for legitimate interests, so just be careful. But you can kind of go down that angle. All right. Again, not legal advice, but yeah, there's detail, right? So this is a slideshow. There's details behind that, so you need to go read up on it if you decide that's going to be your thing. Right. So then the next question is, right, well then, can we just do it? Can we go and collect data from other sources and run and start doing our direct marketing? And no, you still have to process the data lawfully. So POPI and GDPR, all privacy legislations will give you the conditions for lawful processing, or the principles of lawful processing. And there's normally about 12 of them. And specifically under POPI that we're going to talk about today is that you have to notify the data subject. If you collect the data, in fact, Article 14 and Section 18, they both talk about it. If you obtain the data from somewhere other than the data subject, you have to notify the data subject. You have to let them know before you start processing the data, using it for whatever else you think you might want. You need to inform the data subject. Okay. A, that you have the data, where you got it from, who you are, what you intend to do with that data. It's literally a privacy notice. And it's done upfront with complete transparency. And the reason is because the data subject should be in control of whether or not you should have that data and whether or not they're happy about it. Okay. So I'm going to
sorry,
yeah.
can I just ask there, I mean, there seems to be quite a bit there in terms of we're collecting the data, but we should also be then coming back to the purpose and the minimization. So those issues, they also have to be dealt with in this situation, right? So, you know, if we get that consent, but is it in line with the purpose, and how do we go about that?
Well, this is exactly, so I'll give you guys a slide pack, but this is a summary of the conditions of lawful processing. So you were talking about the purpose. There's openness. We need to minimize. Do we need prior authorization? Is it prohibited? Are we justified? Do we have some sort of legal basis for this? Are we allowing the data subject to participate? Are we limiting the data? So are we collecting only what is adequate, relevant, and not excessive? Do we know how long we're going to keep the data for? It's one of the things you have to inform the data subject of. And do our operators delete the data? And then quality and security. So these are the kinds of things you have to ask yourself when you're doing a privacy impact assessment. So yeah, no, you're spot on. Exactly right. So we're going to dive into that in a moment. I'm going to quickly show this data flow diagram. I'm hoping my plan works. I set up a little show and tell for you. I'm hoping it will work. All right. So what I'm going to show you now is the case study where we have a sales, where we're going to buy a prospecting list so that we can augment our marketing, right, and do direct marketing. That's the plan. Right, here it is. All right, so first of all, we have, can everybody see my screen? That's got a red data subject at the top.
Yes, okay. We can. Yes.
All right. So this demo has got two purposes. I want to illustrate my point about the combining data sets, but also want to talk to you a little bit about re-illustrate how to do a data flow diagram, my own sweet version of what a data flow diagram looks like. It's worked very well for me. And just to give you one way of doing it. So first of all, I'm using this tool, this app.diagrams.net. You can use it for free, and you can save the diagram on your laptop. So it's quite nice. It doesn't store it in the cloud. All good data flow diagrams begin with the data subject and where in the world is that person, right? Obviously, when you're buying a data set, you don't know exactly where these people are from. It might be something that you can maybe find out from the company you buy it from. But you always start with the data subject. What did they do? Their data got collected and added to some sort of directory listing, and you sort of hope that there was some sort of terms or service or some sort of agreement with the data subject, between the data subject and the people who collected it. Now, RP in this context means responsible party. And if it's blue, it's a responsible party and other responsible party. In other words, a different company who have their own data protection regulations and their own obligations. And they run their business in their particular way, and they collected it for their purposes. Like these guys, Alicia, they collected for the purpose of being a data broker. And they registered as a data broker, and they do fall under the Massachusetts privacy legislation. Maybe you use LinkedIn to collect your data. If you're using their advertising on LinkedIn, then they have data. Maybe you're using that to augment your CRM. They're obviously owned by Microsoft in California. They obviously also have their own privacy legislations. And their purpose is primarily B2B networking. So in other words, that's the purpose. When I joined LinkedIn, I agreed to the terms of service, which my primary purpose there was to be for networking. They then have shops where they sell this stuff. All right, here comes you. You have your own data subjects that you have collected data from. I'm going to use the example of eventing, right? So you have a webinar or some sort of event. People go jump through some sort of privacy notice, terms and conditions, whatever, to join the webinar, as you did today. So you have an event, you are the responsible party, you collect your attendee data, And the purpose there is B2B networking. Sorry, and I forgot to put in. Yellow means your justification is a contract with the data subject. Okay, so because I've gone through your terms and conditions, you now have a contract with me. Your justification is contract. So that's why you can do this processing. So you take this personal information, you're pretty in control of it. You know that it's only business emails and maybe a phone number, maybe a location. So you're pretty sure it's only personal information. It's not special personal information. And you store that in your CRM, right? Purple meaning that your justification would be legitimate interest at this point. Okay, we as a business need to be able to manage our CRM. And you maybe update your contact list in your CRM. Now, if HubSpot is your example, HubSpot, if you switch on the GDPR functionality in HubSpot, and if you need help with that, by the way, I have a whole brilliant document for you. HubSpot provide a legal basis per contact. A legal basis in GDPR is the same as justification of copy. So you have a legal basis per contact. So we're allowed to process your personal information, which means we're allowed to store you in our contact database. There's a second legal basis in order to communicate with the data subject per subscription list or sequence message. In other words, Outlook email, one-on-one email. Now that legal basis changes based on the purpose of the communication. Okay, so you've got to be careful. You can have one system and one set of data, and your legal bases are completely different. Or your justifications are completely different. All right.
So if I was to ask you, Karen, just as an example, if we had people registered for our webinars, and then you try to sell things to those people who are registered, that would be out of line. Is that correct? So they come for networking, and then you use that to sell. Is that?
Everything's possible. It's just sure. Just how you've just got to satisfy the conditions, right? So it's all the principles. So be upfront. And when you're promoting stuff, it's definitely direct marketing. Okay, we'll talk about that in a minute. And direct marketing, your only legal basis for direct marketing is consent with the data subject. I'll show you now in a minute. Okay, so let me see if my little trick is going to work. Yes. All right. So you go to Lucia or LinkedIn, you buy the data. So maybe you subscribe to LinkedIn's advertising, or you literally go to Lucia and say, I'm going to pay for the database. You don't know if they've got special personal information in there. You need to check that, because special personal information has always got some extra privacy requirements, right? So here you are purchasing the personal information, and look, I'm not a lawyer, but if I had to guess, I think your justification at this point would be legitimate interest. In other words, legitimate interest of my business. That's why I'm purchasing it. What happens next? Well, a whole bunch of things. We take data out of our CRM. So let's say it's attendee details, right? So we want to build a new attendee list, and we want to augment the data. We want to know where in the world the person is, or what their previous roles were, or what their certifications are, something like that. We then combine our data with the data that we purchased. Now, this can still be legitimate interest, but you might be skating very close to needing prior authorization or prior consultation. And I'll give you the conditions when I'll show you in a minute what the conditions are. The other problem is that as you augment data or enhance data, you may very well start moving into special personal information territory, especially if the data you purchased contains special personal information. But the problem is the more data sets we throw together, the more likely we're going to start ending up moving into special personal information, and then it becomes extra risky. So do you see how the data flow diagram is helping us to understand where our risks might be and where we need to look? So that question mark tells me I better deep dive that and understand exactly what data I've got. Right, so now we store that personal information in our CRM. All very good. Then what happens? Now I want to do direct marketing. I want to sell them something, okay? So what I do is I have to go through a process according to POPI and the cookie law in the EU. I have to notify the data subject. This kind of falls under openness, but it also falls under consent for direct marketing. So because I want to do promotional stuff, I have to know, or even if I wasn't doing promotional stuff, I have to notify the data subject that I have got their data and what data I have got, okay? And GDPR actually, and POPI specify exactly what information you have to provide when you give this communication. You want to notify them, and you might combine that with getting consent for direct marketing if that's what you ultimately want to do.
Sorry, Caroline, there's a question from Martin. He's asking, is it even doable notifying and getting consent of the subjects? Or the terms and conditions we as subjects usually accept but never really read? Are they enough?
With data subjects not reading, it's kind of not your problem, but you also are under obligation to make it as accessible and as digestible as possible.
Right,
so you can't go
right.
hiding it somewhere, making it, you have to drive to offices and come read the paper manual.
Right, right.
It has to be very visible. So like, for example, if the notice was CCTV footage is up for security purposes, that has to be like a very obvious sign right at the door where I can't miss it. Okay, so you've got to think a little bit about the customer journey when you're doing this. And I'm a big advocate of plain language. Like, giving me a bunch of legalese in a proper contract format is not helping the situation. Okay, but let's say the data subject does actually take notice, and they do take action, all right? You need to have some sort of procedures or workflows or automation or manual processes, if you're feeling very strong, to manage that input from the data subject and then decide what to do about it, okay? And that is your data subject participation procedures. So participation means I need to be able to access my data. I need to tell you to delete it. I need to be able to object. I need to be able to ask you, under GDPR, we have portability. So in other words, you need to give it to me in a format that I can leverage. So there's all these kind of data subject participations, which are pretty universal. You need procedures and workflows and an understanding of what you're going to do about that data response, the data subject response, okay? And something else you need to do is when this person responds, you might actually have to update the legal basis in your CRM, because you might have had legitimate interest up until now, but now you might have consent. So you need to think about like how we record our legal basis in our CRMs. Now here's the big thing. If I want to sell to them specifically, I have got to have consent, okay? And in POPI, it's a very particular type of consent. Did they opt into the subscription list? So I gave them two things to do. I said to them, I've got your data. This is the data I've got. Do you object? And I gave them the opportunity to participate. I asked them a second question. I said, do you mind if we send you direct marketing messages? Do you mind if we add you to it? Do you want to subscribe? Okay. If they opt in, did they opt in? The first thing is, if they did not opt in other words, you didn't get a response, or they said no, you need to add them to a do not contact list. That's green because you've got to keep a little bit of information like the email address so you can identify them, but it's really minimal, right? This is what I call like almost like cigarette stub, like a little stub of information just so you know who the person is. And under POPI and actually I'm pretty sure under PCR and the cookie law as well, is if the person doesn't respond, that's a no. You cannot contact them again, especially under POPI. You can't go back again and send this email 2, 3, 4, 5 times until they come back and say no. And the POPI, you send it once, done, right? That's section 69, by the way. Right, now, happy days. They did actually say they're happy to be direct marketed to. And then what you do is you communicate with them and say, right, well, in that case, would you mind if we sell you this stuff? Would you mind if we sell you our partners' products? Would you mind if we sell whatever? And you get them to actually opt in. Okay. And from then on, you're dealing with consent and you update your subscription lists and you set your legal basis to consent. So is that clear as mud? Is that kind of... Now, our little diagram here is highlighting this danger that we might need prior authorization depending on how we combine the data sets. Any questions on this diagram before I leave this one?
I really like the diagram, and you know, I think it's fascinating how, for example, as data architects, we build the data flow diagrams, that we don't add a lot of the data privacy issues to it. So it's actually fascinating now as to how much we need to bring these two data flows together. One that's got very much about data privacy, and one that's really just looking at the movement of data and trying to bring them together.
Yeah, and like adding things like flags, for example, helps you to identify this is cross-border flow, right? So privacy legislation has a lot to say about cross-border flow or trans-border flow, which is when you take personal information out of the jurisdiction you're in and you put it in a different jurisdiction. So there are privacy requirements around that, just that upload of the data to America that has requirements.
Now, also, could I ask, in terms of your do not contact list, there's an example of limitation of data, right? Is that where we limit that to the cigarette stub, basically, and that's the absolute minimum that we need to have to ensure that we don't contact them. And that's completely different to purpose limitation or purpose, where we're trying to understand why did we set up this contract and what was the reason for it. So that's a good example of those differences.
And this is something I always say to people, is you really got to understand that you can have your purpose and the data work together. So you can have one data set or multiple data sets, overlay that with purpose, and you start getting very different legal requirements.
Right.
You know, it's for the same data. So it's quite important to bear that in mind.
And Caroline, how would you, so this is quite nice that you've done it like this, but then you'd almost have to have an ongoing check that no one's programmed a data movement or a data flow using their integration tool, and the next minute they're violating this lovely diagram.
And this is why you want to have like some sort of internal policy, like a company policy that says, I personally, the policies that I write for people, I call it restricted processing or restricted data types. So in the policy, I list out the data types that are restricted, and I list, for example, information about children, or restricted processing, for example, automated decision making. Those are highlighted in nearly every legislation. So I put them in there and I say, if you are you going to start dealing with information about children? You have to come to compliance, and you have to do a privacy impact assessment. You have to start doing a compliance assessment, which I'm going to show you how to do it now. Are you going to be doing automated decision making? You need to come and do a compliance check first. And that has to happen. It's like a change impact assessment. You know, in IT, when we like roll out systems or run out changes, we do testing before we do releases. We do change impact assessments before we authorize a change, right? It's the same thing. A privacy impact assessment is a compliance check that you do before you authorize the change. You don't do it after the fact, you know, a year down the line and then kind of go, oh my goodness, what did we do? Did we break the law here?
Especially that now you've introduced that prior authorization. If you do that when the game's on already.
Exactly. So I'm going to give you a little heads up now on what to do about monitoring that exact thing, privacy impact assessment. So the first thing to understand is that you manage risk in your company already. Somebody in your company manages it if you don't, okay? And there's all different types of risks, and we've got all sorts of things. Mostly they are focused around the risk to your company or to your organization. What privacy legislations tell you have to do is to start thinking about the risk to the data subject, right? And specifically, you've got to consider whether or not your processing is unlawful, right? And you have to know what that means, and you have to have ways of checking that. So the key thing is to know whether your processing is lawful. And I'm going to flick through this because we've done this last one, and I've just done it now when Howard jumped the gun. But there are very specific areas, depending on the legislation that you have. This is a sort of a genericized list, that's sort of a combination of different legislations. But for your particular legislation, maybe you only have one privacy legislation that applies to you. Or maybe you're only under GDPR. Then change this, you know, then have the language specific to GDPR, and that's fine. I just, in my experience, have found that most companies end up with more than one legislation. And, you know, you sort of have these pillars of what does it mean for processing to be lawful, right? The question we're going to look at today is, do we need prior authorization? What's the data subject informed? And when when and why their PI was collected. It's one of the requirements. So let's jump into how do we do this. Okay, so stop sharing and share my next thing. This won't take too long. I'm aware of that time. Okay, it's not going to let me do a slick transition. All right. Can you see the spreadsheet?
Really? Yes.
Okay. This is a impact rating for data subjects, for a data subject. So basically, normally in a business risk register, you would have scale of impact on your organization. So we might have fines, for example, or level of fine, or we might have some reputational damage. With data protection impact assessments, you talk about the scale of impact on the data subject. So you go from the scale of, well, data subjects will either not be affected, or they may encounter a few inconveniences, to the data subject may encounter significant or even irreversible consequences. For example, if you lose their fingerprints, right? If you let their fingerprints get on the dark web, I can't go and change my fingerprints, and everything wants my fingerprints. All right, that's irreversible. I can't fix that. And that's why special personal information is such a big deal. Biometric information is part of special personal information. I might suffer financial distress, especially if you'll see just now, if there was an automated decision that created some sort of legal issue for me. For example, no, you're not allowed to buy a house. So if I create, so you kind of risk rated based on how you think this processing might impact on this person. The other thing that you look at is how many people will be affected. It is actually a factor. I mean, privacy impact assessments are supposed to say, look at the individual. If there's one person gets impacted, that's enough, right? It's a human right, and one human is not better than 10 humans. However, scale of impact definitely does play a factor in when we talk about how much money and time are we going to spend trying to be compliant, right? Or making sure we do this privacy impact assessment properly. So if we're going to have a significant number of data subjects, well, then you better pull out all the stops, right? So for example, with this is, if I'm talking about one-on-one communications with B2B networking, that's pretty low risk. If I'm talking about large-scale surveys to the entire nation, asking them for their COVID symptoms, that's massive. So things are different. So privacy legislations are risk-based. Types of information is a big deal. If you're dealing in South Africa specifically with account numbers, and this is why you need to interrogate your particular legislations. So financial account numbers, if you're dealing with criminal or objectionable behavior, in other words, this person broke apart this hotel and you start alerting all the other hotels using your app to alert them, don't let this person stay at your hotel because they're quite dodgy, or even neighborhood watch. Information about children, learners, whatever you want to call them, minors. Just be cognizant of the fact that every legislation has a different age limit for this. In POPI, it's under the age of 18. In UK, it's under the age of 13, and there's a couple of variations in that. And then the type of process, and then of course, type of adults, extensive personal information. Are we talking about schools? Are we talking about churches? Are we talking about clubs? Like, the big difference between a book club and a swingers club, just be aware of what we're dealing with here. So think about the type of information, and then also think about the type of processing. And this is where we talk about unlawful processing or obtaining of disclosure of, so in other words, selling bank account details, not adhering to notices from the regulator, big deal, don't do that. Giving false evidence, even if you didn't know, the law says you should know, therefore giving false evidence, not obeying a code of conduct. These are the things where there are penalties attached. Okay, if something's generally prohibited, it's generally prohibited to process the information of children. But then you get down to where, look, the type of processing we're doing here, we're inviting them to an event, that's not going to impact on their privacy rights dramatically because the event is data management. It's super boring. It's like, no one's going to feel embarrassed that they were found out because they attended a Dharma meetup. So yeah, so that's what we do. We put the scale of impact on the data subject and we build that into our impact rating. Okay, and then we go through the normal. If you've never seen a risk register before, we go through sort of a calculation of 5 of impact times 5 or plus 5 of likelihood, gives us a rating, and then based on the rating, we decide how we're going to handle it. Right. So that's kind of a risk management methodology. So that's how we do a privacy impact assessment.
Carolyn, one of the things that when we do this is we also like to link it to our corporate risk and then ask what level do the executives get worried about, so it's one thing mapping it, but let's say they're very risk adverse, they may be down in the yellow blocks and you've so we've got to be careful.
They'll have a lot of red blocks here, and everything is high risk and everything is get reported. Or like you get other organizations where they're like, look, we only want the 9s and 10s, don't tell us if, anything else doesn't really matter.
Right.
Yeah, so you got that risk escalation facet of it. A privacy risk escalation as a responsible party and a privacy risk escalation as an operator, because remember your role. So you've got the type of data, the type of processing, but also your role at that point will change how, for example, you don't report the data breach to the data subjects if you're not the controller / responsible party. And this is where you document that stuff. Okay. Guys, I'm aware that it's 5+5. Would you like me to continue on to the next section?
Let's maybe ask a few questions now. Are there any questions before we continue? And then if you'd like to ask a question and then go, that will be great. Maybe just a quick pause. Otherwise, we'll let Caroline go on for a bit.
Go on.
Is a bit the understatement.
If you are leaving, this is what I use to build that privacy impact assessment rating. Primarily these WP29 guidelines. They're very good. They literally gave me those descriptions. Okay. Well, we've got quiet house, so either everybody feels good to go or everybody.
I think we should go.
All right. This won't take long. We've been through the bulk of it now, so I just want to give you the rules around prior authorization and prior consultation very quickly. One of the things that you have to get prior authorization for in POPI is if you are enriching data for a new purpose. So in other words, you take your bunch of unique identifiers, right, which all good data projects begin with, and you have a plan to use it for a purpose other than what you intended when it was collected. In other words, if the data subject finds out what you're planning to do with the data, they're going to be a little bit surprised. Okay. This is called further processing in POPI. I think it's also called further processing in GDPR. And you're going to link it together with information processed by another party. So in other words, you're going to combine your data sets. If those 3 things are happening, you need to stop your plans, document your privacy impact assessment, go to the information regulator and request authorization. This has got nothing to do with consent. This has got nothing to do with legal basis or contract or whatever it might be. This is before you even get there. You need to go to the regulator and say, do you mind if we do this? Okay. Very similar in GDPR, Article 35, Article 36. You have to decide for yourself, is this processing likely to result in a high risk to the data subject, right? And there's a couple of, they've got stipulations on that. So legal consequence through automated decision making or profiling, processing large scales, especially if it's or processing special personal information like health information or biometrics, criminal behavior, systematic monitoring of a publicly accessible area on a large scale, so surveillance. And then if the supervisory authority of the Netherlands or the Belgium or whatever decides something is important and they add to the list. Okay, regulators have the right to do that, by the way, in South Africa as well. So the privacy impact assessment indicates high residual risk. And you decide that you can't bring that risk down, no matter what you've tried to mitigate the risk, you can't reasonably mitigate it, and so it's going to be very hard to mitigate. So in other words, you do a privacy impact assessment, it says your residual risk is still high. You then make the decision that actually it's not possible to mitigate this, but we still want to do it. So therefore, you go to the supervisory authority and you get a prior consultation, and they'll basically do their own impact assessment and decide whether or not they will allow you to continue. Okay. There are obviously procedures available. You have to follow for all of these things for South Africa and for GDPR, and in GDPR, in fact, it changes per state. So you have to be really on top of your obligations. Things that for POPI, the way it works is there's a whole bunch of questions you've got to answer. There's a whole guideline document that you've got to fill in that's available on the website. They can take anywhere between 4 weeks and 13 weeks to come back to you. If they don't come back to you after 13 weeks, you can continue. But if they can take up to 13 weeks, and then they can tell you, no, you can't do it. If you have received prior authorization in the past, but you have to reapply if you're going to materially change the purpose of the processing. So if you got prior authorization in the past, now you're going to kind of change what you got. So in other words, your change impact assessment, your compliance checklist must include, does this fall under previous prior authorization? Are we materially changing what we got authorized to do? We have to go back and get prior authorization again. Okay, so it's not like you do it once and then it's done. And that's it, guys. I have now explained about prior authorization. I don't know if I've explained it enough. I hope I have. So that's it for today with enhancing personal information. I'm very happy to stick around and answer questions. Very happy to take, I gave you my details for LinkedIn if you want to get in touch and ask more questions. And I guess that's about it. You can also reach out to me at info@clearwood, and that's about it really, I guess. So does that help? Did that give you enough information?
Yeah, I have a question, and I'm wondering about those last couple of slides where you spoke about publicly accessible data, accessible areas, and I was actually quite interested with when Don's on the call as well, because he does a lot of statistical analysis on things like traffic on the highways or wherever that may be, to get an understanding of what's going on in the economy. Now, suppose it's a little bit about what they're trying to, information they're trying to derive, or what they're trying to say, whether they would need to do something like this. Is that correct? Is that?
Yeah, statistical analysis has its own sort of thing. If you're dealing with entirely de-identified data, POPI doesn't apply. So it just doesn't apply.
Okay.
That's kind of what you hope for. I did recently see what did I see? This is a question I've been asking for about a year, by the way. How does Donald come to know? For about a year, I've been asking, does anybody know how to handle research data? And I finally got something the other day. I'll have to dig it up and find it for you guys. But there was finally a privacy approach. And what is the identification? When is re-identification an issue? And it's beautiful. It's a whole breakdown. It was great. So I'll have to look it up. But yeah, there was an answer finally, which was great relief. Sorry, Don.
Thank you. Just to add to that, so I'd really be interested in seeing that resource if you'd be willing to share it,
Sure.
because it'd be really good to know what exact definition of de-identification is under the regulations. But beyond that, there seems, again, I don't have a good specific sense of this, but my impression is that there's a lot of gray area in terms of to what extent one would need to either tokenize or anonymize data for research purposes, because the real problem from a practitioner's perspective is that you can destroy some of the value in the data from a research perspective, even if you're not particularly interested in the individuals, but you want to understand what you want to be able to classify an individual into groups, and you need an identifier to do that. And so there's a lot of gray area in terms of how you create usable information from identifiable data.
So yeah, and it's a real problem. One of the I do pro bono work for a charity, and they have NACOSA coming to them, and there's a whole bunch of funding available if they can provide data to USAID, for example, right, for HIV status and stuff like that. And of course they want the funding, and of course they have the data. But the question is, do they comply? Like, so if USAID starts saying, well, we don't trust the quality of this data, we need you to provide us with ever increasing amount detail of information. Once you start telling me the age of the person, the nationality of the person, the suburb they live in, the date on which they had some criminal activity that led to an HIV status, it's going to get pretty darn easy for someone in the area to figure out who they're talking about, right? And I've actually seen requests for street addresses of children. And I was just like, whoa, hold on. No, you know what I mean? At some point, the data quality has to happen as a separate thing. So how would I refer them to you to start following your seminars, your webinars on data quality? Because you have to be able to push back sometimes. Now, the thing is that there are ways, for example, if you take combinations of data that you know are unique, and I know how hard this is. I've had to do a master data project before to identify patients in a hospital. Unbelievably difficult to do. In fact, we even found it difficult to uniquely identify doctors, which is interesting because they're registered, right? So you'd think they'd be really easy to identify, but they're not. What you end up doing is creating a very, very, very large set of data elements to uniquely identify a person. One way that people have got around it is that they combine that somehow and then hash it, salted hash, so that it becomes a unique identifier of gobbledygook.
Yeah.
That will always be unique. As long as that list of characters is unique, then the hash will be unique. So, I mean, that's one way to get around that, but obviously you're dealing with personal information until you get to that point. So you've got to have your data privacy hat on until you get to the point where you know for sure this is de-identified. Just so that you know, though, every privacy legislation has got kind of get out of jail free cards of if your processing is for the greater good, or it's entirely impossible to contact all these people and get permission or get consent. There are caveats in each of the privacy legislations for ways to deal with that. So it's not like it's telling you you're never allowed to do any research ever again, because you're going to have to deal with these large data sets of potentially sensitive information. HIV research would stop dead in its tracks. It's more like if the legislations do allow for special situations, and sometimes you have to go to the regulator and get permission. But you can fall back on. There are too many people to contact. It's too difficult to get hold of them. These are indigent people, or these are people, illegal migrants, or so it's just impossible to get hold of them. A lot of people just don't have the same phone number for 2 days. Then you can argue that corner. I'd recommend a privacy lawyer at that point.
I see your hands up, Don.
May I ask a follow-up?
Yeah.
So thank you for that answer. That was very useful. I also wonder where South Africa is compared to other countries when it comes to data sharing regulations. So, in some jurisdictions, it seems that there have been big advances in either the government or specific industries creating templates for data sharing or uh, making it easier for to have guardrails in place and standards in place for appropriate data sharing under the right conditions. One thing having tried to do that ourselves, and we found it incredibly difficult in a South African context, even if you can deal with the hashing issue so that you make sure that the data is appropriately anonymized, and even if you can solve the technological challenges, this does seem to be a lot of, particularly Poppy and a couple of other regulations, seem to be creating uncertainty around data sharing. And my impression is that we don't have enough examples of regulated controlled data sharing that can be used as templates to encourage similar approaches by others.
So yeah, you're right. One big failing in South Africa is we don't have a list of approved legislations. So that's one of the things with this whole trans-border flow, right? In fact, one of the requirements for prior authorization is that if you're going to send information about children or special personal information to a country that doesn't have adequate privacy legislation, you have to get prior authorization. We don't have a list of countries that have adequate privacy legislation, according to our regulator. So we're in green fields. We just don't know, right? What we do though is that we take a defensible position. We say, okay, well, privacy legislation is 80% the same. The objectives are the same. I will go out and have a look to see what other regulators have provided, other case law, templates, ways of working, industry best practices, standards, and I will leverage that as my defensible position until such time as the regulator gives me a guideline. Okay? Then obviously your privacy impact assessment always boils down to that, which, like, if you do a risk assessment and you decide you determine that the risk is not that great, or you've managed to mitigate the risk, you can pull that off. If anybody does complain or the regulator does investigate, that's the kind of thing that you provide as evidence, in case you've got to have records of that. So you basically just fight your corner and do your best and apply it as much as you can, get good advice, and then move forward. Honestly, the goal of privacy legislation is not to stop you from doing what you need to do, right? Privacy is not an absolute right, and there are a lot of caveats in Poppy that will allow certain things to happen anyway. And then like I said, you can leverage international best practice or other regulators. I leverage the UK ICO a lot because they have some amazing templates and insight. In fact, Singapore and those places have brilliant templates, amazing stuff. And you just have to know how to tweak it into Poppies, because there's slight differences. When it comes to the actual security requirements, like protecting the data security, I actually quite like Poppy's take on that, because in fact I've got a whole presentation just on how Poppy talks about security and how it aligns, because it's so principle based, because it's so well worded. You can leverage any international framework like NIST or CSF or any of the international data protection frameworks as your security policy for that data. And you can, as long as you can show that you're leveraging an international standard and that you are looking for risk, you're pretty much okay. Yeah, like I said, whole presentation on that. That's a 2-second summary, but yeah, it's doable. But yes, our regulator is still quite new and quite young, and there's still a lot of things we haven't actually been given. But just so that you know, the African Union and the South African SADC have South African, I want to say development, but it's not. Anyway, SADC and the African Union are actively building digital economy gateways. So allowing free flow of information within regions or cross borders, or having sort of almost like geographic sort of Africa country agreements. So the countries have agreements in place that data flows are allowed with uninhibited. It's a bit like having a visa-free zone or a economic zone. So so that is actively underway at the moment. There's a lot of talk about it on LinkedIn. So yeah, keep a heads up there.
And then Don, maybe to add on to that, I know that, for example, in Saudi, they're building a national data catalog of the major data sets and the data information in the government and in the country. And then they are regulating data sharing agreements. And of course, there's also attached to that is freedom of information. So you can also be challenged at some point to say, well, why have you got that data? Why are you using that data? So it's nice when the country starts to expand the regulations, not just in terms of data privacy, but also data management, in terms of saying, even though this data is open and you can use it and you can share it, they're going a lot more in terms of saying, well, what data sets do we have? What can we share? And then there's an interesting scenario in Italy. There's something called iStat, which is a data quality assessment that is public. And if you want to get any data from any government entity, not only can you get the data, but you can also ask for a quality rating on the data. And every single time it's refreshed, those quality ratings go up and on a daily basis. So they're doing a lot to be able to do good data management on government data and data sets.
Yeah, and I think that's going to become more and more the norm. I think we're going to, everyone's pushing for smart cities and digital governance, digital governance or
transformation,
digital government, e-government, all that stuff. It all requires data.
Yeah.
So I think the data maturity aspect of policy is good. Well, more mature. But what I like about Poppy though is that it's quite well worded. Like the direct marketing, for example. Cookies is a thing, right? And there's EU law specifically around cookies in the UK. But South Africa doesn't talk about that. South Africa talks about electronic messaging stored on an end device. So as long as a message is stored, it's direct marketing. If that aim was to promote, so it's almost like it's really technology agnostic, and you can apply that. Section 69 can be applied to just about any legislation, because I see now Google are moving away from cookies, and they're setting up a whole new way of sharing your data and having new new data market that doesn't use cookies. So, but Poppy will still apply.
Fantastic.
Yeah.
Guys, I think that's. Is there any other questions? I think we've gone quite far over. So,
yeah.
Any last words, Caroline? Is there something more you wanted to say?
No, I think I've said enough.
Fantastic. Any further questions? I think I heard somebody asking a question.
I'm happy, by the way, to stay. I don't mind.
Okay. Fantastic.
Thanks for the feedback, guys. Appreciate it.
Okay. Thank you very much, Caroline. I really enjoyed that.